Hello and welcome to my final video on unincorporated associations, and I want to have a look at what happens when the unincorporated associations they come to an end. So initially it was assumed that the property would revert back to those who provided it in the first place by way of resulting trust. For example, when you put money into a property, you contribute to the purchase price, thereby you gain an interest in it which comes back to you, so by the way of a resulting trust. Or else the property was deemed to be ownerless, in which case it would vest in the Crown. And this was clearly shown in Re West Sussex Fund Trust 1971, where Gough J basically he went through each item, either trying to put it back to those who contributed to it, or gave it to the Crown. And he said that because it was a contract that gave no claim to the property, it was just a contractual relationship that the members had. However, if you understand contract holding theory properly, this is incorrect, and this was confirmed by Walton J. in Re Bucks 1979, where basically what they said is that all the members, they have a beneficial interest in the property because they hold it. Remember, the unincorporated association cannot hold the property, doesn't have a legal identity. However, this beneficial interest is subject to a contract, and therefore being subject to a contract, it's limited what they can use the property for, and it stops misuse of the property. However, when it comes to an end, basically the contracts that govern the way that unincorporated association works and people interact with each other, that also comes to an end. So that means that the members can take the property beneficially as they had done, but subject to no limitation, and are able to use it the way they want. And this seems to be the way that is supported up till today in case law when you look at unincorporated association. The only thing to note is there's a case I think called Davies and Richards and Wellington Industry, and basically the idea of support for resulting trust seems to be coming back. The resulting trust solution is preferred unless there are reasons excluding it, is what the judgment said. But the thing to note is this was concerning pension trusts and employees, so you could say that this is dissimilar and it cannot be applied to normal case of unincorporated association. And as I mentioned before, furthermore, the analysis tends to be is the members have they hold a property beneficially, but what makes them, this is what allows unincorporated associations to be held despite the beneficiary principle. But further to that, they can't walk away with the property because they're bound to a contractual limitation which governs the unincorporated association. But that contractual element comes to an end when the association comes to an end, and thereby giving members freedom to use the beneficial interest they have as they so wish. Thank you for watching. I hope this helps.